Mr. Chairman and members of the committee, my name is Lane Fisher, and I'm a practicing franchise attorney with the firm of Fisher Zucker, a full-service law firm with 12 attorneys and a national practice dedicated almost exclusively to franchising, distribution, and licensing matters in Philadelphia. Our firm litigates franchise issues throughout the country and provides advice on franchise development, regulatory compliance, distribution and trademark issues, trade secrets, and copyright licensing and protection. We also work to create new franchisors, and to that end assist folks in deciding where they want to locate their new franchise businesses, the new franchisor headquarters, so to say. I represent more than 75 systems and many multi-unit franchisees. I'm the chair of the Franchise Law Committee of the Philadelphia Bar Association and a member of the ABA Forum on Franchising, and this is really all that I do. I can tell you with certainty that the bill before you, HB 1620, would completely undermine the franchise model as we know it in the Commonwealth. Franchising is a highly regulated industry. You heard it already from Keith and others this morning. In order to sell franchises in Pennsylvania, a franchisor must prepare and deliver an extensive franchise disclosure document, which we call an FDD, containing detailed disclosures on 23 points of information. It's just not a telephone book of irrelevant information. It is a detailed response to 23 particular points of information that the FTC has deemed material and requires to be disclosed in the course of the FDD. And the contents of the FDD and what is material is something that has been debated for 10 years, and most recently concluding in 2008 when the FTC last amended its FTC rule to require new and additional disclosures. It's very interesting. In the 2007 Statement of Basis and Purpose, published by the FTC, when they amended the rule in 2008, they considered making various changes to the law to read upon some of the relationship issues that Representative Daley's bill contemplates today. And they made two particular findings. They found that the record did not show that any particular conduct was actually occurring, and it did not show that that conduct was prevalent. And in finding neither one of those points, determined that it would pursue filling in what they perceived as gaps to the disclosure law. So the disclosure law, we heard before about how do you know if you're getting into business with an unscrupulous or an inexperienced franchisor. So if you look at our franchise disclosure document for whatever that franchisor is, it discloses the business experience of the folks involved. So if they know a lot about the underlying business or don't, it discloses their litigation and bankruptcy history, so you can see whether or not they've been embroiled in litigation or bankruptcy type disputes. It identifies every single franchisee in the system and has charts that show how many have entered and exited the system during the most recently concluded period. And it goes on and on. And most importantly, it talks about the kinds of purchasing restrictions that that franchisor requires in order to maintain consistency and uniformity. And franchisees, when faced with that disclosure document and the 14-day mandatory cooling off period that they're supposed to read it or take it to somebody else to read it, can decide that they don't wish to pursue this opportunity because they don't want to be bound to such purchasing restrictions. But the FTC relies on essentially full disclosure and full knowledge, and I don't agree with Keith that it's irrelevant information or stuff that is not directly related to the investment decision. There's audited financial statements. There's a prohibition against making promises of earnings, and not unless you do it in your FDD, and then only based on historical operating results. So I believe it is an incredibly worthwhile piece of information. I've actually heard lenders say it's the single best source of information on a particular franchise, and I believe that that way and that methodology and the engagement by the FTC on whether to extend it to various aspects of the franchise relationship demonstrate the fact that there is no problem here to solve. With over 33 franchisors based in Pennsylvania and more than 30,000 franchise businesses here, franchising thrives as a method of distribution. HB 1620 is a solution to a problem that we don't think exists and we think would do a great deal of harm. It introduces vague language, requires franchisors to comply with undefined terms, and frankly changes the parties' bargain for rights in the contract, not to mention imposes criminal sanctions against franchisors for breaching. By replacing a present system that's well-defined and easily navigatable with one which is littered with undefined terms and ambiguities, you'll create an economic disincentive to expand through franchising here in Pennsylvania, and I'll just give you just a few reasons why. So Section 905 holds the franchisor to a standard to act in good faith in the performance and enforcement It requires that everything required under the contract to accomplish its purpose occur, and prohibits any action which prevents a franchisee's enjoyment. I don't know how I would counsel a franchisor on how to not disturb a particular franchisee's enjoyment without knowing the franchisee, his or her motivations for getting into the franchise, or what particular item I might ultimately be held liable and criminally liable for breaching. In my opinion, this will generate massive amounts of litigation by trial attorneys looking for a big payday, and will expose franchisors doing business in Pennsylvania to large, potential, unforeseeable civil and criminal claims, and potentially involve a totally new method of franchising here in Pennsylvania. We believe that any legislation that permits a disgruntled franchisee who disputes his actual level of enjoyment or specific purpose in owning the franchise to obtain a large award against the franchisor to the detriment of all other system-wide franchisees who depend on the franchisor to provide valuable contractual-based services is bad for franchising and a deed for franchises as well. We also, in Section 9.9, find it the prohibition of franchisees being barred from opening businesses where other franchisees exist without a 120-day notice period creates an incredible time lag and really penalizes franchise businesses, particularly in Pennsylvania, but as against every other state franchise businesses and every other independent business, because they're forced to take down real estate in some way that I'm not aware of how you would do that for 120 days while you work through the issues of whether there's an issue with neighboring franchisees who are in proximity, another undefined term. Section 910 voids post-term non-competes on expiration and termination unless the franchisor within 30 days buys the franchisee's business for its fair market value. I don't know what fair market value would be, and I don't know I don't know the level and extent to which taking out non-competes, which is something that we rely on heavily in business sales and in employment relationships and in franchising to protect franchisors' rights to refranchise areas and franchisees' exclusive territories. We think that eviscerates rights granted to both franchisors and franchisees. So I just want to sum up by saying, if I was advising a company that was looking to come to Pennsylvania, I'd have to tell them if they were going to form a franchise here and be subject by this law, that they would have to be prepared to grant franchises which were perpetual. They'd be prepared to not be able to pool purchases here in Pennsylvania, and that they'd have to deputize other suppliers and potentially disclose their recipes and special super secret stuff to more people in Pennsylvania, that they wouldn't be able to enforce their forum selection clauses, that the time to open new units under the terms of their contract are complicated by the 120-day waiting period, and that they'd have to figure out a way to be able to conditionally take down real estate until they know whether the proximity issue is resolved, that they would have issues terminating franchisees who are here, even ones who are underperforming, that they'd have to accept a cure in all cases from franchisees who were in breach previously. I tell them that I think it would slow new store development. I don't know how I would tell them that they would have to understand what a franchisee's enjoyment is or what the purpose of an investment is. And I tell them that every single breach of contract claim in Pennsylvania will be couched as a breach of contract, a breach of competence, and a bad faith claim when it's clearly just a breach of the underlying contract. I would tell franchisor principals who are asking me the same question that they would be subject to a minimum competency requirement that exists nowhere else, that they'd be subject to a limited fiduciary duty, which exists nowhere else, and that they would be subject to criminal sanctions and fines if they didn't comply with these provisions. So I appreciate your time today. Thank you very much.